Start. By way of this appeal, the insurance company has brought in challenge the judgment and award granting a sum of rupees 3 lakh for the death of the sole bread earner of the respondents claimants who had filed claim petition claimed a sum of rupees 25 lakh for the death of Sudhir Mohan Taneja, who died in the vehicular accident and left behind him his widow and 3 minor children. The matter has remained pending from 1998 till date. Before this court adverts to the brief facts, the accident having taken place is not in dispute. The respondents are the drivers and the owner of the truck, which is insured with appellant, which is also not in dispute. The main dispute is regarding the driving license of the driver, and therefore the insurance company could not have been fastened with liability to pay the claimants. Hence, insurance company could not have been made liable, and that the multiplier has wrongly applied. The brief facts of this case are that on 22/4/1992, the deceased, while he tried to board the bus, was not successful in boarding the bus. In the meantime, the truck came from Delhi roadside, which was being driven rashly and negligently, and dashed with the deceased. The driver of the truck tried to overtake the stationary bus from the wrong side without blowing horn, which was driven by one of the opponents, and while the deceased was taken to the hospital, he succumbed to the injuries. The involvement of the truck and it being insured with the appellant is not in dispute. It is not disputed that the truck tried to overtake the stationary bus, and therefore the issue of negligence has not been raised. The deceased was 32 years of age. He was a medical representative, and without waiting an FIR was lodged and the witnesses were examined. It is an admitted position of fact that the driver of the truck did not appear, and therefore when a truck driver tries to overtake a bus which was stationary from the left side, the driver of the truck has to be held to be negligent, which this court holds negligence judgments. This court concur with the tribunal that driver of the truck was rightly held to be, and therefore this court concur with the tribunal as far as issue of negligence is concerned, and the submission made by learned counsel for appellant is negatived. The issue of negligence has to be decided from the perspective of the law laid down by the courts. The term negligence means failure to exercise care towards others, which a reasonable and prudent person would be in a circumstance. Negligence can be both intentional or accidental, which can also be accidental. More particularly, term negligence connotes reckless driving, and the injured of claimants must always prove that the either side is negligent. If the injury, rather death, is caused by something owned or controlled by the negligent party, then he is directly liable. Otherwise, the principle of meaning thereby the things speak for itself would apply. The division bench of this court in first appeal from order number 1818 of 2012, Bajaj Allianz General Insurance Company Limited and Srimati Renu Singh and others, decided on 19/7/2016, has held as under. Negligence means failure to exercise required degree of care and caution expected of a prudent driver. Negligence is the omission to do something which a reasonable man, guided upon the considerations which ordinarily regulate conduct of human affairs, would do, or doing something which a prudent and reasonable man would not do. Negligence is not always a question of direct evidence, it is an inference to be drawn from proved facts. Negligence is not an absolute term, but it is a relative one. It is rather a comparative term. What may be negligence in one case may not be so in another. Where there is no duty to exercise care, negligence in the popular sense has no legal consequence. Where there is a duty to exercise care, reasonable care must be taken to avoid acts or omissions which would be reasonably foreseen likely to be caused physical injury to person. The degree of care required, of course, depends upon facts in each case. On these broad principles, the negligence of drivers is required to be assessed. It would be seen that burden of proof for contributory negligence on the part of deceased has to be discharged by the opponents. It is the duty of driver of the offending vehicle to explain the accident. It is well settled law that an intersection where two roads cross each other, it is the duty of a fast moving vehicle to slow down, and if driver did not slow down at intersection but continued to proceed at a high speed without caring to notice that another vehicle was crossing, then the conduct of driver necessarily leads to conclusion that vehicle was being driven by him rashly as well as negligently. Over.